The Legal Resources Centre is welcoming a High Court ruling declaring the actions of the Ingonyama Trust unlawful. The court also ruling that the trust acted in violation of the Constitution by concluding residential leases of people who are in fact the owners of the land that they're living on. So think about that. You are owning the land and you are paying rent to be on the land. Let's understand how this happened. The Centre's Sharita Samuel speaking to us all the way from Durban. Good morning to you, Sharita. Good to have you with us here on ENCA. Let's talk a little bit about, if we could, the constitutionality of this. It's been an ongoing story, hasn't it? In a nutshell, tell me why you welcome this ruling, and if you could, as simply as you can, how it came to this point, how it was declared invalid.
All right, so we received many complaints from residents on the Ingonyama Trust land over several years. And working with partners such as LAV, CASAC and the Rural Women's Movement, over time, the problems were unending, and it seemed as though the Parliament offered no solution to the people, and so judicial intervention was required. So it was a process of trying to find solutions, and when all of that failed, there was no option but to go to court in order to protect the rights of the residents whose rights had been reduced from informal customary rights to mere tenancy.
So what happens now? Obviously the court has made this ruling, and as you say, the owners of this land have been paying rent on their own land. I mean, as ridiculous as that sounds, for years and years. So when does this court order come into effect, and what's the first thing that's going to happen?
Well, the first thing that has to happen is that the minister has been ordered to take steps to pass law to protect these customary and informal rights. She is required to report at 3-month intervals to the court on the progress that she is taking for those customary land rights to be restored. The other step that is required is that the trust is ordered to refund residents the rental that was collected over the years. And that will have to be managed via the minister, because the court has also ordered that given the legislature or parliament's failure to pass laws to secure people's informal and customary rights, they now have to ensure that the old permission to occupy system is complied with and restored until new law has been passed.
Is this the end of this chapter, Sharita, or do we expect some kind of appeals process on this?
It is very difficult to say now, Gareth. We will have to wait to see what the Trust and its board and all the other respondents' response is to the judgment. As yet, as the attorneys of record, we have not been informed of any further action. But should it proceed, then depending on the instructions of our clients, the LRC will be obliged to fulfill the mandate and defend the appeal should it be instituted.
This kind of ruling, though, has very far-reaching consequences, I'm sure, under law, because this is going to be potentially used as precedent going forward when there are land disputes, whether it's heritage land, whether it's ancestral land, or traditional land as well, which is a very complicated aspect of South African law. It's very unique to our country. Do you think this could change going forward, the fights over ownership of land and claims to land, Sharita?
Well, primarily it is going to affect other parts of the country that also live under customarily held land, in the sense that land does get alienated, land does get treated by different traditional institutions as though it belongs to the particular power that presides over it, when in fact that land actually belongs to the people who have resided there for generations. So we do expect it to serve the interests of similarly placed people who may not have been called on to pay rent, but who actually also suffer from arbitrary decisions taken by traditional institutions. As far as... Go ahead, sorry.
No, please forgive me. I was about to ask you a follow-up question, but I was actually very curious what you were saying there. Please continue your train of thought.
Well, what I was going to say is that it does, the importance of the judgment is that it confirmed that existing rights to property may not be interfered with and watered down. you can take steps to upgrade people's tenure, but their security of tenure is protected by Section 25 of the Constitution, which means that you cannot do anything else that reduces that right.
Property law, I think, one of the founding laws in our country as well. I'm glad to see it's being upheld here as well, Sharita. Help me understand if the Legal Resources Centre, you obviously that I'm talking to, are happy with this. Obviously, it has ruled that the trust acted in violation of the Constitution. They have to pay back the rent to the people who owned the land. It just sounds bizarre even to say out loud. But are you happy with the kind of recourse the court has taken, or would you like to have seen board members, for example, of this trust, the trustees being prosecuted in their personal capacities, or would you like to have seen any further action being taken against the people who were managing this trust?
So we must emphasize that this legal action was not directed at the institution or the individual persons, but rather at the conduct which had this consequence on the clients and the partners that we represented. We had no intention of making it personal against any institutional representatives. It was the conduct that our clients objected to. So it was not an attack on the terms of the on which the trust and its board actually manages the land. It was a specific aspect because the hardship that it caused went to the heart of the kinds of clients and communities that we represent. This was about taking forward the steps to protect the rights of very vulnerable groups. You know, they were required to pay rent that may seem very small amounts by ordinary people, sums of 100 to 800 rands. But these are widows, these are pensioners, these are people that are unemployed, that have very little opportunities in the areas in which they reside. So it was about protecting their security of tenure, because the land is all that they have. They have built their homes there, they have maintained them. So it was to ensure security of tenure for this particular group or these communities, and not intended as a challenge to want to prosecute particular persons. That falls on the Minister and Parliament to take the necessary steps.
Okay, it makes sense to me now. It does make sense. Sharita, congratulations to you and the Legal Resources Centre fighting for those who can't fight for themselves when it comes to land that they own, they rightfully own in this country. Congrats to you and your team. Sharita Samuel, what a pleasure. Legal Resources Centre joining us here on the South African Morning.